Hello, good morning, good afternoon, or perhaps it's evening. My name is Herrcia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because Grenada matters.
Good evening, Miss Willis.
Good evening, or is it afternoon?
It's evening. It's evening for you, right?
Yes, it's evening.
Right. It's good evening for me too. 10 o'clock my time, 6 p.m. your time.
That is correct.
So how you feeling?
I'm feeling good. I'm nice and cool over here.
Fantastic. Well, I'm looking forward to learning a lot more today. This time, the subject today is probate.
That is correct.
Okay, so Miss Willis, first question I'm going to ask you is, what is probate?
Well, probate is the process through which someone gets the court's permission to deal with a deceased person's estate. It's a very, very broad subject. So, of course, with probate, you're collecting in all the deceased person's estate. You're paying off any debts and you're distributing the assets to the beneficiaries. Basically, those beneficiaries who are entitled to those assets. If there's a will, the executors, these are persons responsible for dealing with the estate. When I say estate, that involves all the deceased's assets, personal and real. The individuals, the executors, they are named within the will. They apply to the probate registry for a grant of probate. Of course, if no executors are named or none are prepared to act, then a beneficiary of the will can apply to the probate. But they won't receive a grant of probate that's only given to an executor. They will receive something called a grant of letters of administration. This time with will annexed, so that the will goes with a grant of letters of administration. If there's no will at all, a relative can apply for a grant of letters of administration. So basically, a grant of probate is only given to an individual with a will.
Okay. So then, how do you know if you've got a valid will?
It's usually written on the will that the will is that individual, the deceased's last will and testament. And of course, the will must comply with the Wills Act.
Okay.
The Wills Act is an act of Parliament, and it says the individual must have their signature witnessed. So the will should contain the signature of the deceased individual, which is referred to as a testator, and also the signature of two witnesses. So the testator must sign their will in the presence of two individuals.
Okay. So then what happens if a person doesn't have a will, but there's still an estate out there?
Well, if there's no will, this means the person has died intestate.
What does that mean?
It means the person has not left a will, and there are rules to whom can apply for a grant of letters of administration. Because if you recall, a grant of probate is only if there's a will. So there's a rule of intestacy, and it's usually family members. For example, if the individual is married, it would be their wife or husband, thereafter their children, then their parents, then brothers and sisters. This goes even further because the rules state whether the individual is of full blood or half blood. So there's rules whom can get the letters of administration and the entitlement under these rules.
I've heard stories of people having to get DNA blood tests to prove that they're valid and worthy to step in, to get involved.
Well, that could be at the times, because for you to prove that your entitlement, there must be some connection with the deceased person.
Yes.
This is usually shown by a birth certificate.
Okay.
Or a marriage certificate. The marriage certificate is very clear and simple. Mm-hmm. But where an individual is not, where the deceased is not married to the mother or the father, and their name does not appear on a beneficiary's birth certificate, this is where the problems usually occur. And of course, the best proof in modern times is a DNA. So that is extreme, but that can work.
Okay. So what happens with the debts owned by the person that's died? So I've heard stories that when a person dies, the debts die with that person because it's in their name. So if they're dead, nobody can claim debts on them.
Not necessarily, England.
Okay.
There are actually rules because, sorry, I've taken little notes, little pointers, because this is very important. Okay. Individuals believe when you die, your debts die with you.
Yes.
So if you've left a will, of course, your executor is charged with collecting is responsible also for paying all the debts. So they would need to be thorough with their paperwork.
Wow.
They need to determine mortgages that needs to be paid off, loans and credit cards.
Wow.
They are still there. And of course, utility bills, electricity, so forth. And of course, personal debts, friends and family, that is still payable. That does not die with the individual. Of course, income tax, they always come after you for that. And if there's property, capital gains tax and or inheritance tax. That is determined by the amount of assets the deceased persons has left there behind.
Wow.
And of course, I must add personal debts. An individual who is owed by the deceased can sue the individual, the deceased's estate. And this occurs quite often.
So let's say a member of family owes me, I don't know, £50,000 or $50,000 they owe me, and they pass away. Then what happens then? And if it's a member of my family, I can go and say, well, look, they owe me this amount of money. I'm in this situation at the moment. I'd like a piece of whatever this estate is to pay off my debt that they've left.
Well, if you have proof, you cannot just come and say,
Of course.
Yes, but if you have proof,
bank accounts, bank money being deposited,
that is
transactions.
Correct. Yes, the executor should acknowledge that debt, and you can recover any outstanding amounts.
So wait, let me get this correct. So you're saying to me that if, for example, a member of my family passes away, and there is a will in place, but they have passed away and they are in debt, that estate that they may have, the money from that estate would have to pay off their debts. Am I getting this right here? Would that be part of
the first thing to be paid is the debts?
Wow.
What are the debts?
Wow.
First thing actually to be paid is the funeral expenses.
Now, I want to mention something here that it's sensitive as it is. People that commit suicide, one of the reasons why the high rates of suicide is due to debt and feeling as if, well, I've got all this debt on my shoulders. If I pass away, if I give my life up, then I'm not a burden. But yet, that's incorrect.
That is very, very much incorrect. Not all debts die with you, as I've just explained.
Wow.
Still there.
So you can't go to the, I don't know. You can't say, look, this person's no longer alive. You don't expect any more payments from them. And it's not my responsibility because I'm not that person. Can they not go and do that and shut that down and close that off on that basis?
No. The assets of that individual is there to realize that debt.
So if this stuff were to, so for example, if the estate was to get cleared up and sorted and there was ownership of it, was taken over, then let's say the bailiffs come knocking at the door during that time, and let's say I become the owner of that property. Within my rights, can I turn around and say to them, look, hey, yo, listen, that person that was here, that person's dead and gone. It's not my business. I'm not interested. What happens there? Because I know people that will take that approach.
Yes, that is true. But executor is charged with that. And the first things to be paid before the beneficiaries is the debts.
Oh wow. And there's no
So
way.
if the
There's no
debts,
way around that. There's no
no,
way around that.
no. If the debts are paid first, if there's a beneficiary that's lost out, because usually the monetary bequeaths are the first to suffer.
Yeah.
Yes, and then thereafter, the assets could, and in many cases, are sold to pay the debts.
So that's a mandatory thing. That's not a voluntary thing. That's a mandatory thing for a beneficiary to do. They
That's
can't. So there's no inconsistency about that. Well, one
no,
person does it this way, another person. That's law.
that is law.
Wow. Wow.
That's why it's very dangerous to pay out the beneficiaries before obtaining probate,
Wow.
or even before any payments of the debts.
I mean, going back to this thing about debts leaving with you as you pass away, there are so many deaths that could be avoided just on that fact. Knowledge is power. Knowing that whether you die or you don't die, those or you decide to take your life early, should I say, those debts are still going to remain with you regardless.
That is correct. So this is where life insurance is very, very useful, because that could, in many cases, use to pay the debts, or many times the insurance policy is payable to an individual. So it's earmarked to them. You understand?
Yeah. Okay. All right. I get it. But that just hearing that information, thinking about all these people that have committed suicide because of financial hardship or financial burdens, thinking their life could be ended because of, and they could end their life to get out of it, but there's no get out. In fact, they leave the burden behind.
That is correct. But some also have insurance policies in place, and hence they believe that would be a reason. It is not.
Let's talk about that. So the life insurance, I've got a lot. No, I haven't got life. That person's got life insurance. They decide to commit suicide. They say, well, okay, life is, at least I've left something for my family. Bam, gone. That kicks in now, right?
Do you know some insurance policies have clauses against suicide?
What?
Some insurance policies.
Wow. Better read the fine print. Better read the fine print.
Definitely.
I guess that would become more and more in these life insurances now because of the high rate of suicides.
Yes, but then I think that clause has been there for a long time, because this is something what you've said. Some people commit suicide because of debts and are hoping their debts would die with them.
Okay, so that kind of answers my question with what happens with debts owed by the deceased. I think we've covered that, right? To be fair,
that is correct.
Okay, well, how long does the probate take?
It all depends on the extent of the individual's assets. In simple cases, it could take 3 to 6 months. Well, I shouldn't say 3. 6 to 9 months is more typical of the time period. But then it could take many years. It could be because assets must be sold. It's various reasons. Some estates are very, very complicated, have many different assets, to realize and different types of beneficiaries. So when there's an executor or administrator, because I'm unsure if I mentioned it, but you do, if you get a letters of administration, you're called an administrator, not an executor.
Okay.
So where the executor or the administrator takes out or is granted the letters of administration and the probate, it lasts as long as it takes to administer and distribute the assets. There's no time frame. It could drag on for years.
I've heard that as well. Things dragging on for years.
What
are the sort of things that would cause that sort of delay, though? For years, you want to get something like that over and done with. You really wouldn't want to be, years dragging on to get things. You want to get that move. People probably want to move on with their lives and everything.
Like I've said, it all depends on the assets, because sometimes you have to identify the assets. Some deceased persons, they put all my assets, and the executor administrator is unsure of what assets. So an investigation has to be taken, and that could take years. And sometimes after a executor believes they've distributed everything, something has come up. Even myself, you believe you have collected in an asset, and then you find out the deceased was the beneficiary of lands they didn't know about.
Okay, a question kind of floated into my mind in terms of wills, and let's say the person who's going to benefit from this will, this estate, the rest of the family might have discovered that it's been passed over to somebody who might not be in the greatest state of mind to look after that estate, or they might not be responsible with money. They might be irresponsible. And members of family are saying, look, this this shouldn't be going to this person because they're not responsible. Can there be a petition during that will, or is that a case of that will stands?
If you recall, if you know, the reason, the purpose of the will is the testator, the person who's written the will, is their wishes. And you, as the executor or the administrator, is charged to carry out the deceased person's wishes,
even if that
intentions.
But even if that person's not of a mentally fit capacity to be able to, they may have had a mental breakdown, they may have passed away, then what happens then?
Well, if an individual has passed away,
yes,
their bequeath goes into the remainder of the will. It goes into, and it's I've forgotten the name. It will actually come.
Is it a trust?
No. Right. When a testator writes their will, there's a catch-all clause at the end, which is placed there to catch all bequeaths that is not been included. That goes into the remainder, and the testator usually leaves specific rules for bequests like that, who that goes to.
Okay. Okay.
Still trying to remember the specific legal word. I do apologise to listeners. I can remember the word.
You can always come back to me about it. But at least I've got you thinking. This is good.
Yes.
But
I was thinking I should know that automatically off my head. It's just sometimes you do.
yeah, of course.
The
will. Interesting. Wills are very interesting. This is what I was going to ask you. I know it's slightly off topic because it's in the UK, not so much in the Caribbean. I don't know if the same rules for the Caribbean, but I do know that in England, when there's a certain thing like a inheritance tax.
Yes, I did remember that. I did mention that. That was one of the things that must be paid. Well, all taxes must be paid before everything else.
So the inheritance tax, I heard that it is like if the estate is split in half between two brothers or two sisters, right? One of them have money that has to pay. One of them pays the tax, and the other one doesn't.
No. The inheritance tax is on the asset, on the value of the asset, not on whether one person's get it or not.
Okay.
Right? If you leave property,
yeah,
you pay inheritance tax on that as well. You know, or even finance left over from a sale, you'd have to pay capital gains tax. But when you inherit an asset, property, house, you would pay inheritance tax on that.
Okay.
There are complicated rules on that, potential exemption, you know.
Let us also talk about the power of the attorney. I think this has got to mention the power of the attorney and the will.
Well, that is completely different sphere altogether.
Really?
Yes.
Because the power of attorney. Go on, you tell me. You're the legal person. I'm just going to listen. Go ahead.
You give somebody a power of attorney to deal with your assets when you are alive and you're incapacitated in some way, ill health, you're not able to deal with like a property, and you give another individual permission on your half to deal with that for you. Health wise, you're not able to, various reasons, but a power of attorney exists and lasts. Granting it is alive.
So the power of attorney.
A will is your wishes on your death.
After you've died. So, but the power of attorney and the beneficiary, who has more say?
Completely different again. You're talking about the executor who looks after the estate,
right,
and the beneficiary who receives things from the estate. Remember, I said to you, a power of attorney is when somebody is still alive. There's no power in that when you die. Executor takes over if you have a will, and if you don't, you have an administrator.
So if a person gets the power of attorney while the person's still alive and they operate in an abusive way and start throwing their weight around during that period of time,
the grantor can apply to the court, can revoke it.
Yes.
Or other interested individuals can apply to the court to say that individual with the power is abusing their position. But the grantor is a person who grants an individual, the grantee, the power of attorney. They're alive, so they can revoke it. For instance, your father gives you a power of attorney over his sports car.
Mm-hmm.
You are given that power to drive it. I'm just giving you the basic, to drive it to the mechanic, to have it repaired. But he finds you are driving the vehicle here, then, everywhere. He can revoke that power to you because he never told you you exceeded your power.
Mm-hmm.
Okay?
Okay. 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 That's good. Fair enough. Can't argue that. Can't argue that.
Okay.
Yes. So we've covered probate, how it works. I think the big one for me was the fact that when you die, you don't take your debts with you. Your debts don't go to heaven or hell. They stay right on the earth. Wow.
That is it. Okay, I just remember now. It's called your remainder of your estate is your residuary.
Your residuary. Your residuary.
Estate. And you always have a residuary clause in your will.
Okay.
This is to say what happens with the remainder of your estate. What you've forgotten to include,
Mm-hmm.
where a beneficiary has died and you have not made provision to what happens to their bequeaths. Mm-hmm. That falls into the residuary estate. That's the remainder.
Fine. Okay.
Cool. Remember.
Well done. Excellent stuff. So is there anything else you want to mention about this topic, or are we done on this topic for now?
Well, it's such a broad area of topic.
Yes.
It can always be revisited again. But hopefully I've covered all the salient points, or you've asked the salient points. But it must, and I will go through it again. If there's no will, you have not made a will, the rules of intestacy comes into play. So even if you haven't stated what should happen to your estate and whom should get your estate, your assets, there are rules to be applied to assist whoever will take on that role.
Okay. Okay. All right. So anything else you'd like to add?
That is all the time being. But as I said, we can always come back if anybody would like clarification of any points or any further. I'm more than happy to assist.
Your email address is in the banner, that is the ticker at the bottom. So if anyone wants to contact you, of course, they can contact you. A question to ask you, just a bit more about yourself. What are the areas you specialize in?
Well, my biggest area of specialization is financial services law. But in Grenada, that is not one that's really visited often.
Okay.
But my caseload is probate, commercial, business, most of the general litigation subjects, criminal and civil. In fact, all is needed is to ask, and I cover most areas.
What about family law?
Yes, that is a very broad. I do deal with family law, which encompasses children and divorce.
What's the most common type of cases that you have to deal with in Grenada, would you say?
Property.
Mm-hmm.
I think most lawyers in the Caribbean, that is a very large area, is property. And of course, debt. In this day and age, the 21st century, we're all touched by that topic in the pandemic.
Wow. And how does that? How does the pandemic affect lawyers or solicitors or attorneys at law like yourself?
On an island like Grenada,
Yeah.
I can only say what we're going through. It is not too bad. The courts are still very, very accessible. The High Court, all cases are done by Zoom.
Wow. Okay.
Criminal and civil. Magistrates court, of course, that requires attendance. So only time we really need to leave our offices is to attend the magistrates court. All other matters in the courts are dealt with by Zoom.
Wow, there's something right there. So when you say you're going to court now, you're going to Zoom.
Correct.
So how does that I mean, surely that must save on expenses, right? Because you're not having to get in a car or to drive it's right in front of you.
Yes, but you still have a lot of waiting time. You're still waiting.
Even in the Zoom call.
Well, you're waiting for your turn to go before the judge.
Can't you just log in when it's your time? Like 5 minutes or 10 minutes beforehand? Or is it not as organized as that?
Not as organized as that.
Okay.
So you're put in the waiting room.
And you just got to wait. Wow, that is something, eh? Do you think this system works better, or do you prefer the old school? It used to be.
This system works very well. The only drawback is it's a bit isolating, but that is what the pandemic does. Isolate you, doesn't it?
Yes, in the UK, one of the things that was a big problem during this lockdown or the lockdowns is that people that were getting together, their divorce rates were shooting up and getting higher, and because of that, the courts were overloaded with backdated cases of divorces. So divorces that would have gone through within 3 or 4 months or 6 months, taking 2 years to go through now.
Wow. Well, the waiting time in the courts in Grenada is legendary.
You see?
Yes.
Legendary.
That's all I can say. It's legendary.
Is it legendary in a positive or legendary in a not so positive?
Not so positive.
Oh dear. Okay. Okay. Interesting. Okay. Miss Willis, once again, thank you so much.
Thank you for having me.
Thank you once again. And we look forward to seeing you again next week. Same time, same place.
Thank you very much.
You're more than welcome. Let's see here.
Hello, good morning, good afternoon, or perhaps it's evening. My name is Herrcia Willis. I'm an attorney at law practicing in Grenada for the past 6 years. As a slight background, I'm also an attorney at law in Jamaica and admitted as a solicitor of the Supreme Court of England and Wales in 2000. Well, I'm here today to inform you of wonderful news. I intend to advise and promote law in Grenada because